Most businesses don't lose their trademark because of a lawsuit. They lose them because they made the wrong choice at the very beginning, at the time when they're actually choosing that trademark. In this video, I'm going to walk you through key steps you need to consider when choosing and protecting your trademark so you don't make these mistakes.
My name is Elizabeth Seltzer, and I'm an intellectual property attorney with over 30 years of experience assisting businesses of all sizes in navigating trademark and copyright issues. On this channel, I break down complex legal issues into practical guidance that you can actually use to assist your business.
So the first issue I'll cover is whether or not you're actually choosing a trademark. For example, if you pick a term that describes an actual thing, let's say, for example, bakery, well, you can't claim that that's a trademark because it is functioning to describe the very thing that or the service that you're offering. Then another problematic category for choosing trademarks are those that are highly descriptive, those that use terms that describe the nature or quality of a particular good or service. Let's say you pick the term fresh baked bread for your bakery. Well, that's describing the nature of the goods that you're providing, and those highly descriptive terms are most often very difficult to claim as far as a trademark right perspective, but there are options where a descriptive term may become something that is of recognition by the public, having acquired what's called secondary meaning or acquired distinctiveness, but that's another issue. The best approach is to not pick something that's highly descriptive. Another problematic issue at the onset is if you're seeking to claim trademark rights in something such as a phrase or a design that is purely what's called ornamental. That is, it's just providing ornamentation on a particular product, and it's not functioning as a trademark. That can face obstacles both at the Patent and Trademark Office if you seek to register that ornamental mark, and it also can be problematic in the course of you trying to enforce that ornamental mark against others. So I'm giving you examples of what you should not do, but let's talk about what you should do as far as choosing a trademark. A trademark should be distinctive, and it should serve as an indicator of source for your particular goods or services. What is a distinctive mark? Well, the best distinctive mark types are those that are coined. In other words, you've completely invented a new term or design or combination of both, or even a phrase, and that does not have any ornamental or descriptive or generic elements, and serves as an indicator of source for your particular goods or services. Another strong type of trademark are those that are fanciful. You can choose common words if they can be used in a way such that it doesn't describe a particular attribute of a good or service. An example would be apple. Well, everyone knows an apple is a fruit. However, Apple, the company, chose that, and they were able to trademark it because it had no descriptive or generic attributes in relation to the products or services that they provide. Marks that are descriptive or even fanciful, if they have some means of describing a particular good or service, can be deemed trademark worthy down the road. Again, as I said, if they receive a status that is deemed acquired distinctiveness. But if you don't have the resources financially or the manpower for marketing purposes to reach that acquired distinctiveness level, it's best just to start with marks, phrases, designs incorporating phrases that are not generic, so you don't have to go through the efforts of demonstrating acquired distinctiveness. The best bet is picking something that is truly unique, distinctive, You can go fanciful, but the purely distinctive and coined are the best options for you. So at the beginning, when you're adopting a trademark, another problematic issue is, let's say you've picked the ultimate mark and it may be fanciful but not descriptive or generic, it may be coined, but there's somebody else out there using a very similar mark, and not only is it similar to yours, but it's in the similar field of use that you're serving as far as a good or service. So before you invest time and effort and money into promoting this particular brand or slogan or design, you better make sure that there aren't other parties out there using something similar, because if they are, it will hinder your ability to expand in the marketplace. It may cause an inability to register that particular chosen trademark. So what I'm getting at here is you want to conduct a search. It's called, in trademark terminology, it's called a clearance search. You want to look at not only the USPTO records, but you want to look out into the marketplace to see what common law uses are being made of a mark that may be similar to the one you're adopting. What we're looking here to avoid is called likelihood of confusion. And essentially, likelihood of confusion is the standard that is looked at when seeking to register a mark before the Patent and Trademark Office. The examining attorney who gets your application will look into the issue of whether or not there are other similar marks out there, and if so, on the register or pending before the USPTO as an application. And if there are, then they will issue a likelihood of confusion refusal. In addition, by choosing something that is similar in the marketplace, you're just opening up the door to yourself being hit with an infringement lawsuit. And obviously, it's just not worth it financially to use something that is inviting litigation. A key issue that so many people get wrong is that they think that, oh, I'll just file a trademark application, I'll be the first one to get there, and then I'll be able to just claim rights to this particular mark that I've chosen. That's not how it works in the United States. The United States grants trademark rights to those who are first to use a mark in commerce. And that term in commerce is a very specific term of art, and it's not by just simply running and rushing to the trademark office and seeking to register a mark. So what is use in commerce? Well, for goods, it means that a mark appears on the packaging or on the goods or at a point of sale where the goods are sold, and the product must be sold or transported in commerce. Again, that's very specific and depending on the good being sold. Now, for services, the use in commerce, that means used in connection with advertising or offering of the services, and the services must actually be rendered. These distinctions are important because improper use can impact your trademark rights and your ability to seek registration for your trademark before the Patent and Trademark Office. Another big issue at the onset is who is owning this particular trademark or service mark. Will it be your company, such as an LLC or corporation? Will it be you individually? And this comes into play in the future down the road, both within maintaining that trademark registration before the United States Patent and Trademark Office. It may also be an issue if you ever get in litigation regarding the trademark. So it's somewhat of a sub-issue of related to copyright, but when you go to get your trademark, let's say it's an image or design logo, and you get it designed by a third party, like a graphic designer, you want to make sure that you own rights to that image, and that's usually done through an assignment. That's really a copyright issue. However, there's an interesting nuance here. An image, logo, design can be protected both via trademark rights and copyrights. And you just want this wrapped up at the very onset, at the beginning, when this work is created, because you don't want to get down the road where somebody's claiming rights to your trademark or your copyright. This video will not be completely about how to apply for a trademark registration, but I'll just quickly touch upon some issues related to the application process. You're going to need to go through identifying your mark, showing an image, it's called a drawing page, listing out the goods and services that you will or you are using in relation to that particular mark. And you have to show evidence of your actual use, as I said, with a good or a service. And the details here really matter. And then the USPTO is going to assign certain classification of your good and services. And sometimes you want to make sure that you are properly classifying those particular goods or services. So let's go through the issue of, this is very brief and basic, but if you get your registration, you manage to get through the whole process, and then you have your registration, well, you can't just sit back and say, well, now I have my rights, because you need to maintain your trademark rights. And what does that mean? In general, you need to enforce your trademark. In other words, if you have a registration, you want to make certain that you are monitoring third-party potential infringements. And if you do identify those infringements, that you take action to enforce against those infringements. In addition, you need to maintain your trademark registration. And those maintenance dates come up first within 5 years after you received your registration, and then every 10 years after registration. Trademark registrations can be renewed on a 10-year basis, but the first 5 years is also crucial, because you basically need to demonstrate to the USPTO that you're using the mark as it appears in the registration. And again, you'll need to show proof of use in commerce, and then you need to do that every 10 years when you renew the registration. And as far as enforcing against third parties, if you are aware of these infringements and you let them go on without challenging them for a certain period of time, you are in a situation where you may be weakening your trademark rights. You may even lose your trademark rights. So choosing and protecting a trademark is not just some legal formality. It's necessary to assure that your business is growing and thriving in the future. So if there are any particular issues in this video that I've addressed in general, because I realize this is just very general basic information, let me know if you'd like a more detailed video about a particular issue, and I'm happy to make that. Thanks so much for watching, and check out these other videos to learn more about certain copyright issues.